Welcome to LexTalks Legal Topics Simplified, where we like to break down some of those really complex legal topics step by step for all you law students out there.
Absolutely.
Today, we are diving deep into the world of administrative law.
Yeah.
We're going to explore its evolution and development across different countries.
It's a fascinating journey, this one.
It is.
It takes us from ancient India to modern-day global agreements.
Wow.
And we really see how different societies have approached this relationship between citizens and the state.
So before we get started on our global tour,
Yeah,
let's just step back for a second and clarify what we mean by administrative law.
of course.
You often hear it mentioned alongside constitutional law.
Right.
So how are they different?
Well, you can think of constitutional law as setting the foundational framework for a government.
Okay.
It establishes the basic structure, the distribution of powers, and the fundamental rights of citizens.
Okay.
Administrative law, on the other hand, focuses on the practical application of these principles. It deals with the day-to-day operations of government agencies and how they interact with individuals.
So if constitutional law is the blueprint,
Yes,
administrative law is the construction crew making it a reality.
that's a great analogy. I like that one.
Thanks.
Think about applying for a driver's license.
Okay.
The Constitution might guarantee your freedom of movement,
Right.
but it's administrative law that sets up the agency, the DMV in the U.S., for instance.
Yeah.
That processes your application, conducts driving tests, and issues licenses.
Okay, that makes a lot of sense.
Yeah.
So let's start our exploration with India.
Okay.
I've heard that administrative law has incredibly deep roots there.
Yeah, that's right.
Is that true?
You might be surprised to learn that sophisticated administrative structures existed in India centuries ago,
Really?
particularly during the Maurya and Gupta dynasties.
Wow.
These empires had elaborate systems for tax collection, maintaining law and order,
Okay.
and managing public works. All functions that we now associate with modern administrative agencies.
So the concept of a government managing daily life
Yes.
is not new in India.
Not at all.
Okay.
And this long history has really shaped how modern administrative law has developed in India.
Right.
Of course, British rule also played a significant role, introducing concepts like codified laws and a hierarchical court system.
Right, the East India Company and all the regulations they brought in.
Exactly.
Yeah.
But after India gained independence, there was a distinct shift towards a welfare state model,
Okay.
with the government taking on a more active role in areas like social welfare,
Okay.
economic development, and public services.
So the government's reach expanded significantly.
It did, and with that expansion
Uh,
came the need for a stronger framework to ensure fairness and accountability.
Makes sense.
Indian courts have played a crucial role in developing principles of judicial review,
Okay.
striking a balance between the need for effective governance and the protection of individual rights.
So in India, we see this fascinating interplay between a rich historical legacy,
Yeah.
the influence of British colonialism,
Mm-hmm.
and the challenges of a modern welfare state.
Absolutely. Now let's shift gears and head over to the UK, the birthplace of common law.
Okay.
It's interesting how their approach to administrative law was quite different initially.
Yeah, it is surprising. I would have
Yeah.
thought they'd have embraced it right from the start.
Right.
What happened?
Well, there was considerable resistance to the idea of administrative law in the UK, especially in the 19th century.
Okay.
A prominent legal scholar, A.V. Dicey, famously argued that there was no administrative law in England.
Interesting.
He strongly believed that the ordinary courts were sufficient to protect citizens' rights,
Okay.
and that separate administrative courts, like those in France, were unnecessary and potentially dangerous.
He thought having separate administrative courts
Yeah,
could threaten the balance of power.
that's right.
Interesting. But as the government's role expanded, surely they had to develop some form of administrative law.
You're right, it became increasingly difficult to ignore the growing regulatory activities of the state.
Yeah.
The two world wars, in particular, led to a massive increase in government intervention in the economy and society.
I could see how that would necessitate a system for managing those activities fairly.
Yeah.
What were some of the key turning points in the UK's acceptance of administrative law?
Two major milestones were the Crown Proceedings Act of 1947
Okay.
and the Tribunals and Inquiries Act of 1958.
Okay.
The Crown Proceedings Act, for the first time, allowed individuals to sue the government for wrongful acts,
Wow.
a significant step towards holding the state accountable.
Yeah.
The Tribunals and Inquiries Act brought more structure and oversight,
Okay.
to the growing system of administrative tribunals,
Uh-huh.
which were handling a wide range of disputes outside the traditional court system.
It sounds like the UK went through a period of realizing that the old way of doing things wasn't sufficient for this new world.
Exactly. As the 20th century progressed, the UK, despite its initial resistance, developed a robust system of administrative law,
Uh-huh.
albeit one that is still rooted in common law principles and emphasizes the role of the judiciary in upholding the rule of law.
So both India and the UK developed administrative law in response to changing societal needs.
Yes,
It makes you wonder how other countries approach this.
indeed. Now let's cross the Atlantic and take a look at the United States,
Okay.
where the development of administrative law was closely tied to the rise of the regulatory state.
This is around the time of the Industrial Revolution, right?
You got it.
Yeah.
The rapid industrialization of the U.S. in the late 19th and early 20th centuries brought about a host of new challenges.
Okay.
From monopolies and labor unrest to unsafe working conditions and environmental pollution.
A lot of issues that needed to be addressed.
A lot of issues.
It makes sense that the government had to step in.
Exactly. And this intervention took the form of creating regulatory agencies, like the Interstate Commerce Commission to regulate railroads and the Federal Trade Commission to prevent unfair business practices.
So these agencies were tasked with setting standards and enforcing rules within their specific areas.
Precisely. They were given quasi-judicial powers,
Okay.
meaning they could conduct hearings, investigate complaints, and issue rulings,
Wow.
all outside the traditional court system.
That's a lot of power.
It is.
Did this raise concerns about accountability and potential overreach by these agencies?
Absolutely.
Yeah.
The growth of these powerful regulatory agencies
Yeah.
led to a surge in litigation and debate about the proper scope of administrative power and the need for judicial oversight.
Okay.
This, in turn, spurred the development of key administrative law principles in the U.S., including the right to due process in administrative proceedings,
Okay.
the requirement for agencies to provide reasoned explanations for their decisions,
Makes sense.
and the power of courts to review agency actions for compliance with the law.
So you can see how the U.S. system, like those in India and the UK, was shaped by the need to balance effective governance with the protection of individual rights.
Yes, and this theme continues as we explore a system that at first glance seems entirely different.
Okay.
France's Droit Administratif.
Droit Administratif.
It's a unique approach that has influenced administrative law worldwide.
It sounds so intriguing. I've heard a bit about it, but what makes it so distinctive?
Well, Droit Administratif is a separate body of law specifically dedicated to administrative matters.
Okay.
It's not just a branch of the general legal system. It has its own set of rules procedures,
Wow.
and even its own court system, the administrative courts.
Wait, so if you have a dispute with a government agency in France, you don't go to a regular court?
That's right. You would go to an administrative court,
Huh.
which is staffed by judges who are specialists in administrative law.
Exactly.
This separation between the administrative and judicial branches aims to protect the efficiency and autonomy of the administrative process.
So they believe that having separate courts leads to more expertise and faster resolution.
Exactly. And another key aspect of Droit Administratif is its strong emphasis on protecting citizens from arbitrary government actions.
Okay.
The administrative courts have the power to review agency decisions,
Uh-huh.
not only for legality, but also for their proportionality and adherence to general principles of good administration.
So it's not just about whether the agency had the authority to act,
Right.
but also about whether they acted reasonably and fairly.
Precisely. Droit Administratif places a high value on ensuring that the administration acts in the public interest and respects the rights of individuals.
Okay.
It might surprise you to learn that despite Dicey's early criticism,
Uh-huh.
common law countries like the UK, the US, and even India have adopted elements of Droit Administratif over time.
That is surprising. I guess good ideas travel even across different legal systems.
They do.
What are some examples of these adopted elements?
One notable example is the increasing use of specialized tribunals in common law countries.
Huh?
In the U.S., you have tax courts, bankruptcy courts, and immigration courts,
Right.
all handling specific types of administrative disputes.
Yeah.
Similarly, the UK has a well-established system of tribunals dealing with employment, social security, and other areas.
Okay.
This specialization allows for greater efficiency and expertise in resolving administrative matters.
So there's a recognition that sometimes you need judges who have a deep understanding of a particular field
Yes.
to make informed decisions.
Exactly. And another area of convergence is the expansion of grounds for judicial review.
Yeah.
Courts in common law countries are becoming more willing to scrutinize administrative decisions,
Wow.
not just for procedural errors, but also for substantive fairness.
Okay.
They're looking at whether the agency's decision was proportional, whether it considered all relevant factors,
Right.
and whether it was properly justified.
These developments reflect a growing emphasis on protecting individual rights and ensuring accountability in the exercise of administrative power.
Yes, they do.
It's fascinating to see how different legal systems can learn from each other and evolve over time.
It is.
And this brings us to the even broader context of global administrative law.
Right. As our world becomes increasingly interconnected through trade technology and shared challenges like climate change,
Right.
we're seeing the emergence of international agreements and institutions that establish rules and principles for administrative action on a global scale.
So there's a growing recognition that administrative law can't be confined to national borders.
Precisely. One prominent example is the World Trade Organization, or WTO.
Okay.
Its agreements not only set rules for reducing trade barriers,
Right.
but also include provisions aimed at ensuring that member countries have fair and transparent administrative procedures.
No.
For customs, valuations, import licensing, and other trade-related matters.
That makes sense. You can't have a fair global trading system if countries are using arbitrary or opaque administrative practices.
Exactly. Another important example is the Aarhus Convention,
Aarhus Convention.
an international treaty that focuses on access to information,
Okay.
public participation in decision-making, and access to justice in environmental matters.
So it's about empowering citizens to hold their governments accountable for environmental protection.
That's right. The Aarhus Convention recognizes that individuals and communities have a right to know about environmental risks and to participate in decisions that may affect their environment.
Makes sense.
It also sets standards for how government agencies should handle environmental information and public participation.
These examples show how administrative law is evolving beyond national boundaries
Yes.
to address global challenges. It's interesting to see how administrative law principles that we often think of as applying within a single country are now being applied on an international level.
It is, and this trend towards a global administrative law raises important questions about how these international norms interact with domestic legal systems and how they can be enforced effectively.
It makes you wonder what the future holds for administrative law.
Yeah.
As we navigate a world of globalization, technological advancements,
Right.
and increasingly complex challenges, it's clear that administrative law will continue to play a vital role in shaping the relationship between citizens and the state.
I agree.
Welcome back to LexTalks.
Yeah.
In this final part of our deep dive, we're going to shift our focus to you, our listeners.
Okay.
We've received some really insightful questions,
Right.
and we're excited to tackle them. It's clear that you're grappling with some of the key issues in administrative law.
Absolutely. Let's jump right in.
Okay.
Our first question comes from Sarah in California.
Okay.
She asks, I'm a bit confused about judicial review.
Mm-hmm.
If administrative courts are separate from regular courts, how can regular courts review their decisions?
It's a great question, Sarah, and it gets to the heart of how different legal systems approach the relationship between administrative agencies and the judiciary.
Right. The answer, as with many things in law, is that it depends.
Okay.
It depends on the specific legal system in question.
Okay.
Let's start with France and its unique system of Droit Administratif.
Okay.
As we discussed earlier, France has a separate system of administrative courts that handle disputes between citizens and government agencies.
Right, and they have their own set of rules and procedures.
Yes.
But what happens if someone is unhappy with the decision of an administrative court?
Okay.
Can they appeal to a regular court?
In France, appeals from administrative courts go to the highest administrative court,
Okay.
the Conseil d'État.
Conseil d'État.
It's a fascinating institution because it acts as both an appeals court for administrative cases and a body for judicial review.
So the Conseil d'État can review the decisions of lower administrative courts
Yes,
to make sure they're in line with the law.
exactly. It has the power to annul or modify administrative decisions that it finds to be unlawful.
Wow.
The Conseil d'État plays a crucial role in ensuring that the French administration acts within the bounds of the law and respects the rights of citizens.
Okay, so that's how it works in France.
Right.
But what about common law systems like the US or the UK?
Yeah.
How does judicial review work there?
In common law systems, things are a bit different.
Okay.
Regular courts have the power to review the decisions of administrative agencies,
Uh-huh.
even though there might be specialized tribunals handling certain types of administrative cases.
So you might have a specialized tribunal dealing with, say, Social Security benefits.
Right.
But ultimately, a regular court can review its decisions.
That's right. It's based on the principle of judicial supremacy.
Okay.
The idea that all courts have a responsibility to uphold the rule of law,
Ah.
even when it comes to administrative actions.
Makes sense.
This means that if you think an agency has acted unlawfully, you can go to a regular court and ask them to review the decision.
But are there any limits to what courts can review?
Yes.
They're not going to second-guess every decision an agency makes, are they?
That's an important point. Judicial review in administrative law is generally limited in scope.
Okay.
Courts are primarily concerned with whether the agency acted within its legal authority,
Okay.
whether it followed proper procedures,
Wow.
and whether its decision was reasonable.
Okay.
They're not supposed to substitute their own judgment for that of the agency.
It was about making sure the process was fair
Right.
and the decision was within the bounds of the law,
Yeah,
not about whether the court would make the same decision.
exactly. Judicial review is a delicate balancing act.
Right.
It's about holding government agencies accountable while also respecting their expertise and the need for efficient administration.
Our next question comes from David in New York.
Okay.
He asks, you mentioned that common law countries have adopted some elements of Droit Administratif.
Right.
Can you give some specific examples?
Of course, David. As we talked about earlier, one clear example is the increasing use of specialized tribunals in common law countries.
Right.
Think of the tax courts, immigration courts, and bankruptcy courts in the U.S.
Yeah.
Or the various tribunals in the UK that deal with employment disputes,
Uh-huh.
Social Security claims, and other administrative matters.
Right. And the rationale behind these specialized tribunals is that they allow for greater efficiency and expertise in resolving these specific types of disputes.
Precisely. And another example of convergence is the development of more robust grounds for judicial review in common law countries.
Okay.
Courts are becoming more willing to scrutinize administrative decisions, not just for procedural errors, but also for substantive fairness, drawing on principles found in Droit Administratif.
So they might look at whether the agency's decision was proportional to the issue at hand
Yeah,
or whether it was properly justified.
exactly. It's a reflection of a growing emphasis on protecting individual rights and ensuring accountability in the administrative process.
Our final question for today comes from Maria in Argentina.
Okay.
She asks, with the rise of artificial intelligence and algorithms, do you think administrative law will become obsolete?
It's a fascinating question, Maria, and one that legal scholars around the world are grappling with.
It is.
While I don't think administrative law will become obsolete,
Okay.
I do believe it needs to adapt to the challenges of the digital age.
This is something we touched on earlier. As governments increasingly use algorithms and AI to make decisions,
Right.
it raises a whole host of legal and ethical issues.
It does.
How can we ensure these systems are fair, transparent, and accountable?
Exactly. We need to think about how traditional principles of administrative law, like due process rationality and judicial review, apply in this new context.
Yeah,
How do you ensure an algorithm is making decisions in a lawful and non-discriminatory way?
right.
How do you provide meaningful oversight when decisions are being made by machines?
It seems like we need new tools and approaches to address these complex questions.
We do. And this is where the creativity and adaptability of administrative law come into play. We need to develop new frameworks and safeguards to ensure that these powerful technologies are used in a way that benefits society and respects individual rights.
That's a great note to end on. It highlights that administrative law is not a static set of rules, but a dynamic field that's constantly evolving to meet new challenges.
Absolutely.
So to all our listeners out there, keep those legal brains buzzing. Keep asking those tough questions. And remember that administrative law is not just about rules and regulations. It's about shaping a fair and just society.
Well said. Thank you for joining us on this deep dive into the world of administrative law.
Yeah.
We hope you found it informative and engaging.
Thank you for listening. Subscribe and stay updated with LexTalks.